Please be seated. The court is now in session. Today, the chamber continues to hear the remaining testimony of witness Prakon and begins hearing testimony of another witness, that is through TCW 808. However, before we proceed with hearing the testimony of the upcoming witness, we will hold a proceeding to hear responses from parties to Nuon Chia's request to postpone the trial proceedings for a period of 4 weeks. And that is in relation to the updated list of S21 prisoners by Office of the Co-Investigating Judges. And we will also discuss this matter as well as related documents related to the updated list. Ms. Jia Su Huang, please report the attendance of the parties and other individuals to today's proceedings. Greffier, Mr. President, for today's proceedings, all parties to this case are present. Mr. Nuon Chia is present in the holding cell downstairs. He has waived his right to be present in the courtroom. The waiver has been delivered to the greffier. The witness who is to conclude his testimony today, that is Mr. Prakon, as well as Mr. Momrati, his duty counsel, are present in the courtroom. We have a reserved witness today, namely through TCW 808, who confirms that to his best knowledge, he has no relationship by blood or by law to any of the two accused, that is Nuon Chia or Khieu Sampon, or to any of the civil parties admitted in this case. The witness will take an oath this morning before the Iron Club statue, and Mr. Mueang Sawan is his duty counsel. Thank you. President, thank you. The Chamber now decides on the request by Nuon Chia. The Chamber has received a waiver from Nuon Chia dated 2nd May 2016, which states that due to his health, headache, and back pain, he cannot sit or concentrate for long, and in order to effectively participate in future hearings, he requests to waive his presence at the 2nd May 2016 hearing. He advises that his counsel advised him about the consequences of this waiver, that in no way it can be construed as a waiver of his rights to be tried fairly or to challenge evidences presented through or admitted by this court at any time during the trial. Having seen the medical report of Nuon Chia by the duty doctor for the accused at the ECCC, dated 2nd May 2016, which notes that Nuon Chia has a chronic back pain when he sits for long, and recommends that the Chamber shall grant him his request so that he can follow the proceedings remotely from the holding cell downstairs. Based on the above information and pursuant to Rule 81.5 of the ECCC internal rules, the Chamber grants Nuon Chia his request to follow the proceedings remotely from a holding cell downstairs via and audio-visual means. The Chamber instructs the AV unit personnel to link the proceedings to the room downstairs so that Nuon Chia can follow. That applies for the whole day. And the Chamber now hands the floor to the defense teams. And the defense teams are reminded that you have up to 11 o'clock this morning to put question to this witness, and that applies to both defense teams. You may proceed.
Thank you, Mr. President. Good morning, Your Honors. Good morning, Counsel. And good morning, Mr. Witness. Let me start my questions with with following up something you said last week, and that is in relation to the interrogation of John. At 14:12 hours, 28 April 2016, you said regarding John, whom I personally interrogated, torture was inflicted upon him, although it was at a minimum. Further down a bit, at 14.19, you said the way that I beat him, that was a form of torture, and that is the hot method. I checked also the Khmer transcript of what you said, and in both instances you used the word Tiarunakam. That word Tearunakam, was that word generally used within S21?
President Mr. Prakon, have you listened to the question? If so, please respond. The Council stated that you use the word Tirunakam in Khmer or torture, which is a legal term, and whether the word Tirunakam or torture was commonly used at S21, or whether there was an order from the upper echelon to mistreat prisoners to confess, or whether the word Tirunakam or torture was ordered during your work at S21 prison. Witness. I apologize, Mr. President. Just then I could not see the red light on the tip of the microphone. In fact, the word Tirunakam or torture was commonly used at S21.
Regarding this word, Tearunakam, at 27 April last week, at around 14:05, the President of the Trial Chamber made a general remark about the use of that word, and he said the following, and I will quote him literally. That could be a discrepancy in the use of the language, that is, in Khmer and English. And for that reason, counsels, you should limit yourself to other terms, probably like inhuman and degrading treatment, because the word Tearunakam in Khmer, or generic torture definition, is really common in the Khmer context. For example, when a father disciplines a child, we also use the same word Tearunakam, and that could not be legally defined as torture. So the word has been invited within the behavior and tradition and culture of Cambodia. End of quote. Mr. Witness, I would like you to react to the words of the President, more particularly to the example that he gave. When a father disciplines a child, we also use the word Tearunakam.
For my personal understanding, that term is a common term. And in the Khmer context, we use two words, that is Tver Bab, that is ill treatment, and Tver Terunakam, that is torture.
But do you remember in those years between 75 and 79 the word Teorunakam could also be used for disciplining a child who did not obey the orders of the father?
I do not have a thorough understanding in terms of comparing the word Tirunakam to the beating of a child by the father. However, if there is the case, then we can say the father Tver Tirunakam or torture to the child, which is a common term.
Council, just a second. I appreciate the discussion. It's important. But obviously we need to be careful not to get lost in translation now. If you make a point of it's used for disciplining a child, I think the next question should be how to discipline a child. You can discipline a child by doing this and by beating it half dead.
I agree, Judge Vance, and I'll follow up. If this word Teorunakam can be used also for disciplining a child, what exactly would that disciplining mean? What kind of acts would fall under that word, acts done by the father?
The act by the father to the child, to my understanding, that is when the father disciplines a child or tortures a child. To my understanding, I have the same perception, and I cannot tell you much more than that.
I understand. Let me move on. Let me move on to the interrogation of John. I asked you quite a bit of questions about his interrogation already last week. Let me follow up on this, Mr. Witness. You said at 1412 Teorunakam was inflicted upon him, although it was at a minimum, and that you said, and I quote, at 1412, I used nearby tree branches to beat him, to beat his hand, legs, and back. End of quote. Do you remember whether John was in severe pain after you beat him?
I can recall that I threw three branches to beat John. Of course, it was painful for him since I was beating him. And it is typical when somebody is beaten, the person is in pain.
Let me be more precise in my questioning, Mr. Witness. Did John start bleeding after you beat him?
When he was beaten with small tree branches, he was not bleeding. However, we could see the marks from the beating on the skin.
When you beat him, did he break his hands, his feet? Did he break any limbs of his body?
Allow me to clarify again. There were only marks of the tree branch beating.
I understand, but just to make sure there's no misunderstanding, did he faint or did he become unconscious after you beat him?
No, he did not become unconscious.
Was it at any point in time for you necessary to stop the interrogation and to call a medic to treat John?
No.
Those marks from you hitting him with tree branches, did that leave permanent scars?
The marks would disappear within a day or two, and allow me to confirm that at S21, medics only would treat the prisoners if there were open wounds from the beating, but if there were only rashes or red marks from beating of tree branches, the prisoners would not be treated by medical staff.
Thank you, Mr. Witness. Now let me follow up these questions with showing you a document. Mr. President, I would like to show document E3/8368 to the witness. That is in English translated as a document called Statistics List of Special Branch S21. The ERN numbers are 0 in Khmer 00007445 and following. English 00225379 and following. French 002787444 and following.
Yes, you may proceed.
Mr. Witness, you have been quite extensively asked questions about this very document. The lawyer of Duik asked you all kinds of questions. And I will follow up on those questions. But if you have a look at the orange underlining, marking in the document, these are the excerpts that were read out to you in full by the lawyer of Duik. So if you could have a look at the orange excerpts.
President Duty Council Mombratir, please assist the witness to see the relevant segment so that he can understand it and respond to the question. Judge Levin, you have the floor.
Yes, we do not have the excerpt underlined, so I'd like to see how the Chamber of the Parties could identify the segment in question, since we haven't seen it underlined.
Anticipating that question, Judge Lavergne, the excerpts that I highlighted are coming from E3/7464. That's the transcript of 22 July 2009. And it starts at around 1400, where Duick's lawyer, François Roux, starts asking questions about this very document. And it goes on all the way until 1415.
But
regarding your question, I can say that there is the opinion and the instructions from Dutch. While I was there, I actually applied all the instructions from Dutch. And that's his instructions that he gave to us, to all the interrogators during the study session at S21. And he also instructed us on how to interrogate, how to make a summary, that is a 1 or 2 page summary of the confessions, and only mention the important points on the summary so that he can review it.
Mr. Witness, because of time, I will not repeat all the excerpts that were read out to you by Counsel Roux. Whatever he read out to you, as I just said, you agree to. One general question first. I don't believe he actually showed you the document, so now you have it in front of you. Do you recognize the handwriting of that document as belonging to presumably one of your colleagues?
To my recollection, the handwriting belongs to Mom Nai Elis Chan.
And why is it that you say that? What makes you recognize his handwriting?
I used to see this handwriting, and if it is the handwriting of Kang Kek Il, it is more complicated and difficult to read. But Mom Nai's handwriting is neat and easy to read.
Now let me go to something that I would like to ask you specifically, and maybe the standby counsel can assist in finding the exact page in Khmer. Mr. President, I'll be referring to Khmer ERN 00007458, English 002253888, and French 00278752. for standby counsel, I believe it is highlighted in orange or yellow. So the Khmer page is ends on 5.8, if I'm correct. Mr. Standby Counsel, is one of those orange tabs. Well,
President, Duty Counsel, please refer to the EIN number ending with 58. And please, you should also notice the tab, the yellow tab at the side of the paper.
Go ahead.
Duty Counsel, Mr. President, I cannot find page 58. I saw highlights on the other pages. President, Court Officer, please take the document to the Defense Counsel and show whether that relevant page is highlighted. If not, inform the Chamber.
Well, I'm not able to read Khmer, but I'll read it to the witness if that goes faster. 50. Mr. Witness, it says on that page, directions, it's a chapter called Directions in Improving Work. It says 1, use politics as the basis. 2, examine and compare the responses consciously before, in English, torturing. And point 3, and that is a question that I would like to ask you about, respect organizational discipline when interrogating. For example, do not beat if not instructed to do so, and must consider the health issue before beating. Do not do anything other than what was instructed. My questions in relation to, go into relation to point 3, Mr. Witness. When interrogating Chon, did you consider the health issue before you beat him with a tree trench?
But answer. The health issue of Chon at the time was good. However, at the time, there was a rule or regulation of Dutch. Unless we had the permission or regulation from Dutch, I could beat the prisoner.
A little further down in that same document, Mr. Witness, in Khmer, page 65 at the end, 0007465, French 00278756, and English 00225391. It says on the chapter Views and Stances on the Enemies whom the party have arrested, it says, confess to the party in order to live and not die in place of their leaders. Make them think of their wives and children. End of quote. When you interrogated John, did you make him think of his wife and children?
That was the method of interrogators, that they used the political pressure. That was the technique, and also was the technique was also to allow the prisoners to think of the wife and the children of them, so that they could give the confession.
Mr. President, in light of the answers just provided for by the witness, also in light of your considerations in the judgment, more particularly 2.441, paragraph 241, and chapter 2.7.1.2, paragraph 484. In light of those considerations, we are arguing, will be arguing right now, that the confession produced by John was not the product of torture. The beating that the witness describes was such that it might fall under inhuman and degrading treatment, but even that is unclear. In light of the answers that he gave in respect of document that I just showed him, taking also into consideration the Supreme Court Chamber's ruling as to probabilities of someone being tortured, I think now we have reached a stage that I can use John's confession and ask a few particular questions relating to what's in the document of John's confession, which is E3/1549.
Bonjour, Monsieur le Président, Madame.
Good morning, Mr. President, Your Honors. Good morning to all the parties. Here again, we have another attempt to revisit this debate that has not yet been clinched. Today, the Chamber will receive the submissions of the various parties, including a response to the motion made by the Nuncia defense regarding other confessions. I would like to simply say very rapidly that there is a presumption that torture was used. The Supreme Court Chamber has already ruled on that. This witness, having worked as a member of the chewing group, told us that most of the time persons referred to him for torture had already been interrogated by the cool or hot groups, which means, Mr. President, that psychological and physical torture had already been used, as in the case of Chun, before the witness was interrogated. All the questions asked by the defense focus on the first day of interrogation of Chun, and these questions do not cover the entire interrogation, which covers 600 pages of interrogation notes. for that person. And I don't think we can conclude on the basis of the answers provided by the witness that he was not treated in such a manner that would consider that the definition of torture under the convention was met. We're not only talking of physical torture, but we're also talking of mental and psychological torture. And it is, by the way, on this point that we argue, and we do so in our pleadings today, that such interrogation, given the detention conditions under which the detainees were held, and we've said so very clearly, they were held either individual cells, they were shackled, they were not able to sleep properly, they lay on the floor, they received very little food, either in collective cells or individual cells, and the conditions of detention were very, very severe, and they risked dying at any time. And given the fact that they could hear screams of people who were subjected to hot treatment, and bearing in mind the fact that they were detained in S21 under those conditions, and we have already heard of the psychological pressure brought to bear on all the detainees. They made them think of their wives and children, and they were subjected to suffering. And for all these reasons, we conclude that there are risks that they were tortured, and the defense hasn't been demonstrated to defense that torture was not used, and so we cannot use the contents of the confessions of Chun during these proceedings and later. Thank you, Mr. President. I want to make some brief remarks following what the co-prosecutor has said, and he has already said most of what I had to say. We object to the use of these confessions because the defense has not shown proof that the risk of torture did not obtain in the case of this witness. We insist on the fact that there was psychological torture, and the Supreme Court chamber, in its ruling regarding the use of S21 confessions, recalled that there was a climate of extreme fear that was prevalent at S21, and that we must take into account that ruling when you have to consider the issue of the existence of torture at S21. Torture goes well beyond physical torture, as the co-prosecutor has pointed out. Anything that caused moral suffering or psychological suffering would fall under the definition of torture. And the absence of risk has not been shown by the defense. We are tendering before this chamber our response to the Rule 92 motion on the kinds of treatment that were used. For all these reasons, the defense should not be authorized to use the confessions of this witness.
If I may respond briefly, Mr. President, the conditions or the criteria or the requirements for the definition of torture as laid down in the torture convention have not been met at all. It's a very wide and broad definition that both the prosecution and civil party lawyers offer. It's conditions in the prison, the climate of fear is simply not a part of the definition, part of the criterion. And let me, I refer to you already to your own paragraph 484, and let me read to you what it actually says. It is about himself being involved in maltreatment, and it says the following: the chamber notes that some of the accused's statements at trial regarding his involvement in torture were unclear or contradictory. Chamber is not satisfied, however, that kickings or beatings by the accused have been proven to the required standard, nor that the slapping of chit-il caused pain or suffering of the severity required for a finding of torture or other inhumane acts. unquote. That's a very clear ruling, very clear example as to how we should interpret certain behavior in this particular case of Duik. It is our argument that John's treatment didn't even come close to what is being described in paragraph 484. Again, the requirements have not been met. Therefore, I think I'm entitled now to ask a specific question on Koitun and the 1977 coup d'etat plans that I can read in John's confession and which was made and drafted by the witness.
I have a couple of additional factual questions. I'm not entering into the legal debate at the moment. Can you remind us how often John was interrogated?
Regarding the interrogation of Chon, I cannot recall how many times I interrogated him, but I recall that I completed the interrogation of him.
But if I understood you correctly, it was more than once. But did I misunderstand?
That is true. More than one, but I cannot recall how many times I interrogated him.
I remember you told us that he wrote down a confession. You didn't like it, so he had to be interrogated again to write down the next confession. Do I remember that correctly?
That is true. What he was writing in the confession, it was not the dissatisfaction of me, but the upper echelon or my superior was not satisfied with the confession after I sent to Duik and Chan above me. And after the dissatisfaction of them, after they were not satisfied with the confession, they put an annotation, and after that the older confession document was burned, and later on I had to re-interrogate that person.
How did you know what would satisfy your superiors? You said the original confession didn't satisfy them, they sent it back. How did you know what they wanted to hear, basically?
I know about it because after I sent the document, and then there was no news or no returning a document to me, I knew that it was well done, but if a document was referred back to me, I had to interrogate the prisoner again, but I cannot tell you for sure how many times I did the interrogation on that person.
I understand. What I want to know is, in John's case, you got the confession back, the first one, because your superiors didn't like it. How did you know what they wanted for the second confession, or third or fourth?
I know that the confession that I compiled was to their satisfaction, since they kept the confession, and I received a letter for interrogation other people rather than John after that.
Somehow I don't get my question through. Let me be more specific. You sent John's interrogation to the superiors. They sent it back and said, interrogate again. Did they give you guidelines for what questions to ask? Did they tell you, we want specifically to know whether he was, don't know, CIA or whatever?
But សំណួរដែល
They sent me a written note on the suspicious points. For instance, they may have asked me about the networks that the person was engaged in, and that point needed to go further in the interrogation.
So to be clear, if you remember John, but generally, if a person hadn't talked about networks originally, it could come back, the confession could come back from the top saying, ask them about networks. Is that true? Did I understand that correctly?
But
Answer: tracking down the network in an absolute manner. Actually, that was not the point of the questions they wanted me to ask, but I was required to ask about the string or network of traitors, where they were.
So you were required to ask these questions by your superiors. Is that true?
But
Answer: yes, that was the question.
Do you ever remember a case where a person did not talk about networks after he had been interrogated again and again? Do you remember such case?
I do not remember it. I cannot recall it. About the interrogation, or in particular that the interrogation that you asked.
More easy. Was there ever a person who didn't confess? After having been interrogated repeatedly, and to be clear, I'm talking about your experience.
Some prisoners confessed and some other did not. I did not. I was not able to get the confessions from all the prisoners, and some prisoners said that they did not know about what I asked. So it depended on the prisoners.
What happened to those who didn't remember or who didn't confess?
but
Regarding the interrogation of prisoners after they did not confess, they would be ill-treated and tortured.
Again, give us an example what would happen to them in order to avoid the loaded terms ill treatment and torture. Tell us what you did to them.
For those who did not confess, I would write only the confession that the prisoners made after inquiry or after further interrogation. They did not confess, so I would write the same thing as in the previous confession.
Understand that. But you said if they didn't confess, we went on torturing and ill-treating. So tell us what you did to them. Don't use the word torture and ill-treatment. Tell us what acts you did. You talked about beatings. What else?
Judge Vance, you already testified that he didn't use.
You are not interrupting me, counsel. I know I'm repeating it, but I think we should be in context.
He said it already.
But
Whenever the prisoners did not confess, I would further interrogate those prisoners by imposing further question, and if still not confessed by the prisoners, I would use torture.
Again, what did you do to them? Don't say torture, describe what you did.
but
The acts or in torture I meant here are the same. President interrupts. Mr. Korn, in fact, it is now controversial on the use of the word torture. Torture is the legal term, and the word torture is defined in the International Convention. And the question from Judge Fan is about the acts that you used against the specific prisoners. So could you describe the specific acts that you use in order to obtain or extract the confession from the prisoners? So what type of acts you used at the time? Answer. The acts were beating and put the plastic bag on the head of the prisoner so that the prisoners were terrified, and after that provided the confession. But sometimes those kind of acts were not successful in extracting the confessions.
So the idea was to terrify, to use your words, the prisoner.
but
That is true.
Two more questions. These relate to John now. One is very minor, but you were talking about branches all the time. What kind of branches are we talking about? Something this size, like a pencil, or something this size, which is basically 6 to 7 centimeters? Can you give me an idea of what kind of branches we are talking about?
but
It's equal to the size of the pen, and if it is as equal as to the size of wrist, I can say that it is a club, not a branch. And usually the branch could not lead to a severe wound or open wound or bleeding. That was the small stick that I used at the time.
My last question, you said you had ordered to tell prisoners to think of their family. Can you give me an example on how you did that? What did you tell the prisoner? What did you say?
During the interrogation, I would use the reasons that the wife and children were awaiting them at their houses or home, and if and I would tell the prisoner that if they did not confess, so when will they had a chance to go back home to visit their family members? So the method was to deceive the prisoners to give confession.
Can you give me an example, a sentence you would have said at that time?
but
I cannot recall the sentence that I used since it happened a long time ago. I cannot recall it well. But the method was to use the psychological pressure and bringing up the issue of family members and reminding the prisoners that the wife and their children are waiting them at home. So the method and the technique was to deceive the prisoners so that they provided the confession. So it was the deceitful act used at the time.
And my last question, only if you can answer it. Do you know if other prisoners knew what happened to prisoners who didn't confess? Was that well known among the prisoners' population, if you know?
On this particular point, prisoners were detained in different cells and far away from one another, so they did not know what kind of confession one prisoner gave. They were not aware of other confession by other prisoners.
I understand that they didn't listen to the confessions. But did they know what kind of treatment, as if you know, did they know what kind of treatment was handed out to people who didn't confess? You don't know, tell me you don't know.
I don't know.
President, the Chamber decides that parties, based on the confession of Chun, which is a document in case 002/02, to use it as the basis to question this witness. The Chamber needs to review in details that document, as well as responses from parties to the submissions by the Defense Counsel. We need to review that document in detail in comparison to the International Convention Against Torture. For that reason, Counsel, you are prohibited from using that document to question this witness.
Perhaps to add, if following the submissions which we'll get today and the decision by the Chamber, we decide that the document is allowed, we'll recall.
I understand. The only thing I would like to have on the record is the two particular questions I wanted to ask, so that it is clear which specific reference I'm talking about. It's fine if the witness puts off his headphones, he doesn't have to hear it. But I think it's important for the discussion which particular excerpt from the confession I would like to confront the witness with.
We are not discussing in any way, and thereby putting it before the Chamber, contents of the confession before we've made a decision whether this is in line with the torture decision.
I understand, but I'm not talking about networks. I'm talking about something very specific, and I think it is important that the Chamber understands what it is that I'm specifically asking questions about.
Oui, Monsieur.
Well, just to signal to the Chamber, because you have reviewed these confessions, that beyond the three documents that relate to these confessions that are already on the case file, there's E3/3680, there's E3/1549, and E3/4280. Beyond that, if the Chamber is willing to read 1,709 other pages of confessions by the same person, they are available in Khmer at 00261079 and to 00262831. And these are not pages that are not on the case file yet, however. However, I note that the three documents on the case file cover a period between February of 77 to May 77, so that's a period of more than 3 months.
President, allow me to reiterate that the document is prohibited from being used as a basis to put question to this witness. It is now appropriate to have a short break. We'll take a break now and resume at 10:30. And court officer, please assist the witness unit break time and invite him as well as the duty counsel back into the courtroom at 10:30. The court now is in recess.